Then There's California, a podcast featuring members of the California State Senate Democratic Caucus discussing their lives, legislative priorities, policy, and other related issues that help make California exceptional. From the state capitol in Sacramento, I'm Brian Green. Since 2017, the Me Too movement has been shedding light on the extent to which so-called non-disclosure agreements, NDAs, have protected powerful men accused of sexual harassment or assault. In 2018, in the wake of those sexual assault and harassment revelations and the muzzling effect of those NDAs, SB 820, the STAND Act, Stand Together Against Non-Disclosure, was signed into law in California, which ever since has allowed employees the freedom to publicly discuss factual information relating to sexual violations in the workplace without legal consequences. And this year, in 2021, Governor Newsom has signed into law SB 331, known as the Silenced No More Act, and it takes effect in the new year, 2022, and it will prevent the use of NDAs in workplace situations involving any form of discrimination or harassment. On this edition of Then There's California, we'll look back on the controversial and sometimes ugly history that non-disclosure agreements have in the American workplace. We'll talk with the tenacious legislative author of both NDA-focused California laws and her efforts to help change the pernicious climate and culture that employees in California often confront. And we'll also be joined by a former tech worker and now equity advocate and now tech accountability advocate who courageously defied a non-disclosure agreement to make public the racial and gender discrimination that she'd experienced in her previous employment in the tech industry. State Senator Connie Leyva of Chino has been an unwavering policy and advocacy champion for California's workers throughout her career, so it makes sense that she is the author of both SB 820 and SB 331. Senator Leyva is the chair of the Senate Democratic Caucus and the chair of the Senate Education Committee, and not to mention one of my original and very fondly regarded podcast guests, and she joins us now from her district office in Pomona in the 20th Senate District. Senator Leyva, welcome back. How are you?
Hi, Brian. I'm doing great. Thank you for having me today, and so excited to speak with you and IFOMA on this just such an important topic and issue.
It's good to hear your voice. And yes, this discussion about secret workplace NDA settlements and advocacy on behalf of workers would not be complete without the counsel and perspective of Ifeoma Ozoma. It was Ifeoma's courageous defiance of workplace racial and gender discrimination and disparity and the Non-Disclosure Act thrust in front of her that has put her at the forefront of NDA reform advocacy, not only nationally but on a global landscape. And she is tireless in her continued efforts to give advice and empowerment to employees who have experienced discrimination in their work and want the agency and freedom to bring it to light. Ifeoma is the founder of Earthseed, a consulting firm supporting individuals, organizations, and companies on the issues of tech accountability and public policy and health misinformation and related communications. And she is the co-sponsor and fearless ally with Senator Leyva in the creation of SB 331, the Silence No More Act. Ifeoma Ozoma lives in Santa Fe, New Mexico, which is where we find her now. Ifeoma, it is a privilege to have you join us. Welcome to Then There's California.
Thank you so much, Brian. I'm so excited to be here today with Senator Leyva.
Santa Fe sounds like it would be a beautiful place to be this time of year.
Oh, it's gorgeous. It's 65 degrees outside right now, and at night we get into a low of around 30, which is perfect because I love it. I love it chilly, having grown up in Anchorage.
And not to get too far into our narrative here, but I suppose Santa Fe is a nice place to escape the maddening crowd, you might say.
Oh, in every single way. I feel like I live sort of a double life because all of the work I do is very much online, but my life all around me is with my 9 chickens, my 2 dogs, my cat, and lots of time outside.
I think Senator Leyva and I are sounding envious here.
Yes, very envious. So your chickens, I'm guessing, lay eggs. I have always thought that would be fabulous.
Oh, it's the best. And I recently got into making ice cream the French way using their yolks.
Wow.
That's awesome.
This is the perfect way to start this conversation, seriously. But for both of you, I know it has been a whiplash couple of years in regards to your respective efforts and advocacy on behalf of workplace safety and parity. And in particular, I know, Senator Leyva, your work has borne fruit in the wrap of a successful legislative session and in the passage of such an impactful bill as SB 331.
Absolutely. It was a really good year for Team Leyva, but it was also, more importantly, a good year for all of the folks who helped us with these important bills, most importantly, SB 331, the Silence No More Act. Workers should always have the right to speak up and talk about things that are happening in their workplace. Otherwise, how can we ever expect employers to change? If they have to sign a non-disclosure agreement, a secret settlement, then any of these workplace violations that are happening are not going to come to light. And employers, we'd like to think they'll do the right thing, but they won't unless they're forced to. So this has been just a phenomenal bill to work on, and to be able to work with IFOMA, it's just been awesome.
As a former labor leader, I know you are all too familiar, as you say, with the workplace and employment violations and the legal hoops that employers and bosses go to firewall themselves from consequences of what is often already established patterns of egregious or illegal behavior. But it was the Me Too movement and the attempts of powerful predator bosses like Harvey Weinstein to silence the young women who worked for them, or even women they just encountered in these nightmarish situations, that actually led you to focus in the last couple of years on what NDAs are and their silencing and career-ruining force that they play in someone's life. Talk about that.
Yeah, absolutely. And I think, Brian, the last part that you said is so important, career-ending issues. People forget, or they don't realize, or they don't want to take into account that when a person, and of course with SB 820, most of this was sexual assault, sexual harassment, sex discrimination, and most of it fell onto women's shoulders. And there were men too, but mostly it was a woman's issue. And people look at, he or she got this really big settlement, $10 million, $20 million. But what they forget is this person walks away. They have no career. They don't get to do what they love. They lost everything because someone was allowed to treat them the way they did. So being able to do SB 820 and going after people like Harvey Weinstein and so many others, it was awesome to be able to work on that. But then when IFOMA came to us and talked about what was happening at Pinterest, and it was clear that we had to close the loop, that harassment, bias based on race, on ethnicity, sexual orientation, age, disability, religion, etc., those were still hanging out there. Those were still issues that employers could hide behind through a secret settlement or a non-disparagement clause. So I was thrilled that she came to us and allowed us the opportunity to work on this issue. And now, of course, it's the law. It's amazing to me that in the last 3 years we've been able to do things that I think will have a big impact on workers, whether you're in the tech industry and you make a lot of money, 6 figures or more, or you're working in a hotel, or you're working as a janitor. These are bills, now laws, that will help workers everywhere, which is very exciting.
And IFOMA, it sounds like you and Senator Leyva really could not have found a better ally in each other in this fight to bring this bill into law.
That's exactly right. And to Senator Leyva's point, and your own as well, there are so many folks within and outside of the tech industry who don't get those large settlements. Even in my case, it wasn't $10 million. It wasn't $1 million. I got less than a year's severance. And what Pinterest did, and many employers do this as well, is they tie your ability to retain health insurance to signing those agreements. So
Right.
It's not just compensation. It's not just your ability to feed your family and pay to have a roof over your head. But in my case and many other workers' cases, during a pandemic, I had to decide whether or not speaking up was worth losing health insurance. And that is not a real choice.
That is not a real choice. You know what, IFOMA, I don't think I realized until right now that part of your agreement was tied to getting health care. That just makes me even more angry because every human being needs health care. Wow. These employers are unscrupulous.
Ifoma, I know you have been so visible and poignant, really, in sharing your experiences and fighting against racial and gender discrimination in your career in the tech industry. I know you've done so many interviews on this subject along with Senator Leyva, but I'm sure each opportunity to tell your story brings clarity to the discussion. So back us up a little bit and tell us how you got into the tech industry, your experiences and legal battle with discrimination that you and a colleague experienced working at Pinterest, the image sharing and social media service, for those who may not know what it is. And then fast forward, how you found yourself as a workplace discrimination and NDA breaker policy ally to Senator Leyva.
Yes. So really quickly, the background on how I entered the tech industry, my entire career has been in tech. I interned for 2 summers in a row at Google while I was still at Yale, and immediately after graduation, was met with the choice of either going to law school and taking on a ton of debt or going ahead and starting work without that debt. And for me and for my family, what made the most sense was going ahead and starting work. And so I started out on the public policy team at Google in DC. I ended up moving a few years later to Facebook out in California. So that's what moved me to the West Coast and closer to family who is still in Alaska. And then from Facebook, I was recruited to be the second person on the public policy team at Pinterest. And so I was there before the company went public, which is a huge opportunity for any worker, but specifically for me and my career and the work I was interested in. It allowed me to build the public policy work at the company from the ground up in a way that the company was excited about and benefited from, because all of the IPO coverage and all other good press around Pinterest had to do with the work that I was leading and that I started there. But then also for me, gave me the opportunity to do work that I really believed in and that I was so proud of. But at the same time that I was doing that work, I was also trying to push the company to live its values and to do the many things that it said it was doing in marketing and in sales work. It was a company that supported women. It's a company, for those who know about Pinterest and who use the platform, it's mostly used by women. And so the company on the one hand was doing all of these things and saying all of these things that made it seem like it was a place that was supportive for women and a great workplace and a great platform, while I was also the public face of a lot of the public policy work we were doing, but being underpaid, being retaliated against. And at one point, I was actually doxxed by a colleague, and the company did next to nothing to protect me because they were not interested in me staying there. So it actually worked out for them that a colleague was harassing me because they were doing everything they could to just get me out of the door and shut me up.
Wow. Well, and I just want to say that when Ifoma and Erica initially came forward and I read their history and their bios, I just was so impressed. I'm like, these women are just off the charts smart and hardworking and doing everything right, but they're still being treated this way and still ended up losing their jobs. So it just made the impetus for 331 seem all the more important.
I mean, I have no illusions about the way that corporations work. Much of what is done is marketing in the service of sales and in providing profit for shareholders. But for me, it was personally hurtful and offensive to see the hypocrisy of the same comms and legal teams who were behind pushing me and Erica out, then putting out a statement weeks later saying that they not only thought that Black Lives mattered, but that they supported Black employees, when the folks who put together those statements knew that not to be the case and were actively working against the interests of the employees who had built up the company.
You broke with Pinterest, and obviously an emotional and extremely difficult and probably financially compromising situation, but you were muzzled, if you will. You were censored by this non-disclosure agreement that you had signed with Pinterest, right?
That's right. And one of the things that I thought about carefully in coming forward was the fact that the company could bury me in a lawsuit. Many of the folks who questioned why there was the need for 820 and for 331 would say, well, at the end of the day, don't most judges throw out non-disclosure agreements? And that may be the case, but you're bankrupted on the way to that decision, because it's not just the final decision you're paying for. It's hours and hours and months of depositions. It's all of the paperwork you and your attorneys have to put together to get to that point. It's the fact that many people, while they're in the middle of a court case, can't keep their job, can't find childcare or whatever else it is that they need in order to be fully part of a trial. And so the companies know this, and they drag things out and make things as miserable as possible for folks. And for many people, you can't even get to the point of going to court and duking it out because you just can't afford to. You can't afford to hire counsel. You can't afford to even risk losing whatever little severance you receive. And so we need to have public policy, and why I'm so proud of this bill, that doesn't put the onus on individuals, and particularly low-wage workers who are supposed to then be equal somehow and fighting a multi-billion-dollar or trillion-dollar corporation. It's just not reasonable.
And Ifoma, no one could say it better. What you said is so accurate. Companies wait people out. They know that you need childcare. You know that you need to eat, and they don't care. They have almost a limitless supply of money. And you're right. This is why we need good public policy. But we also need people like you who are willing to come forward, because you put everything on the line. So I will always be grateful and indebted to you, because I couldn't have done this legislation without you. So thank you very much.
Thank you.
So, Ifoma, how did you feel when Pinterest said that they came out in support of the bill when we were still working it through the legislative process?
Oh, I don't know how many times I laughed seeing that. I'm still close with a number of people who work at the company. And so that morning that happened, that was in April, it was just such a whirlwind, because I had heard from a number of former colleagues and then from people who I'd worked with at Facebook and Google and who I went to school with, saying they were so proud of the op-ed that I'd written and that was published that very morning in the New York Times. And then 4 hours later, I think it was when I started hearing from people still at Pinterest at the time saying, "You will not believe this. Ben, the CEO, is now in support of this bill that you're co-sponsoring. And even though he takes great pains in this email to not mention you or Erica or anyone, it just seems like he's spontaneously supporting this. This is what he's saying." And, I definitely laughed at it. The irony was not lost on me. But at the end of the day, it's huge that people at Pinterest who I used to work with and those who I never worked with and will never be in contact with are now protected because of this work and because of the sacrifice that we made in coming forward.
That's right. I wondered what your reaction was, because when Jessica, my ledge director, who I know you spent a lot of time with, came in to tell me, I was like, what? I said, no, they're not allowed to support it. And she's like, Senator. And I go, I know, I'm being irrational, but this is what companies do. Now, all of a sudden, they want to look like the good guys. And I said, oh, why? Did they call Erica and did they call Ifoma and offer them their jobs back? I doubt it. Companies never cease to amaze me.
Senator Leyva, did you get as much silence from the corporate world as you did opposition to this bill? Because to some degree, pushing back against NDAs implies that there are problems in the workplace that you just don't want the world to know about.
Yes, Brian, that's 100% right. Their silence was deafening. And I think one thing that was interesting about this bill is that we did get to a point where we were able to get the California Chamber of Commerce to go neutral, which was very surprising. They usually hate all of my bills. So the fact that they went neutral was very surprising. To me, that was kind of an admission that they know that these companies needed this, and that if you're not doing anything wrong, you wouldn't have any problem with 331. So, we were happy to have them on in neutrality.
I want to do a deep dive into the dynamics of NDAs. As ubiquitous as NDAs are in the workplace stratosphere, most people don't understand NDAs, and likely most employees who have one thrust under their noses in the wake of a workplace legal scenario, or even at their hiring, don't fully grasp their significance or their muzzle or binding power, even with counsel at their side. And sometimes I know they are considered, especially in settlement arrangements, as actually what is best for the employee and their family, and even encouraged by counsel to accept. Talk about that.
Well, I would just say that 95% of people who sign an NDA have no idea what they're signing.
Right.
And when you sign as a condition of employment, or you sign it because you want this job or you need this job, you're not going to take the time to research what this actually means. And employers know that. So workers sign it because they need the job, and then years later when they are being harassed, they find out that they signed this. FOMA, I would defer to you and see what you think, but I would say 95% of people who sign an NDA don't even know they're signing it.
I agree with that completely, and that extends to all forms of concealment clauses, whether it's forced arbitration or non-disparagement or non-disclosure agreements. They're written with such perfect legalese that sometimes even if you have counsel advising you, they're not sure what it means. Something that Mariko Yoshihara and Jessica Stender from the California Employment Lawyers Association and Equal Rights Advocates, respectively, have said is their own clients and the lawyers they work with have said that they don't understand half of what's included in these agreements. And so you're put in this position where in order to decide whether you're able to speak up and on which issues, you then have to be willing to risk a court battle. And that's not what we want, because it's just honestly ridiculous that you can work somewhere for 6 months or even 6 years and they can hold your silence for the rest of your life. That's not American. It shouldn't be.
No, that's exactly right. And I think this is maybe not the tip of the iceberg, but there's just so much that these corporations do, and they will spend millions of dollars, to your point of FOMA, with the legalese, so that, you know, me as a layperson, I'm going to read it and think, oh, yeah, this sounds fine. But then when you have an attorney, as you point out, that may even think, oh, I'm not even sure what this allows you and doesn't allow you to do. It just shows that most corporations really stack the deck against workers. They just want you to come in, be quiet, let us treat you however we want to treat you, and work hard and let us make lots and lots of money off of your back. I think that's why I love being in the labor movement for so many years. A union contract can really level the playing field for workers.
Is there a situation in a company or in a workplace dynamic where an NDA is still perfectly legal or helpful, and we talk about, for example, disclosure allowances for unlawful workplace acts versus disclosure protections for employers and business practices? We don't want the employees going out there and disclosing company secrets involving a product or something like that.
Right. So NDAs that go to, you know, Coca-Cola's secret ingredients to make it Coca-Cola, employees can still sign off on those, or McDonald's secret sauce. But when it comes to workplace treatment, no. And, you know, when I was in the labor movement, I still tell workers to this day, I say, unless it's illegal or immoral, you have to do what your company asks you to do. For too many years, people have been forced to do illegal and immoral things, or they would lose their job.
Well, one of the patterns that I have noticed in learning about NDAs, they are this legal Band-Aid, this liability shield that is shadowing or hiding already established patterns of dysfunction or bias or discrimination, harassment, or law breaking, literally, that have been going on for a long time, or they're even part of the culture and the nomenclature of a business or a corporation. And many times the workplace isn't filled with all of these litigious employees running around with counsel at their backs ready to sue. They're just trapped in a bad and chronic situation. And then somebody thrusts a NDA under their noses in the wake of a scenario, and they don't even know what's happening, sometimes even with counsel at their side.
Absolutely.
That's right.
Yeah, FOMA, your thoughts. I think that's 100% right.
Yeah, that's right. And one thing that I've made sure to note in conversations about this is the use of concealment clauses like non-disclosure and non-disparagement agreements don't only hurt workers, they hurt shareholders, and they hurt those who are invested in having a business be successful, and that meaning all of the ways in which a business can be successful. As a shareholder, it should be important to you to know whether there's unlawful conduct going on at a company that you invest in. You should know whether perpetrators of abuse and harassment are being held accountable. And so even though often the conversation is individual worker using their name versus company, and that's the way it's set up, what it really is a company's legal structure protecting individual abusers and perpetrators versus individual workers. And I think when the conversation is laid bare in that way and we understand exactly who is being protected and how, one solid example is the Weinstein Company protecting Harvey Weinstein versus all of his victims, then it's easier to have the conversation because it isn't just company and the company needing to do what's right for the company, because as we've seen and as we know, at the end of the day, everyone benefits when abusers are held accountable.
Absolutely. And I think sometimes that the shareholders are kept in the dark, maybe by the executive board, so they don't even know that the company is doing this. Or I always wonder, too, do they even care? Are they just worried about, making their dividends and making a profit? But Ifoma, I totally agree. We are a better society when people who are investing in a company know what they're all about. And by getting rid of NDAs and secret settlements, as I said earlier on, it gets rid of this behavior. And it also allows people, maybe I'm out looking for a job, and now, I don't think I want to put my resume in over here because it doesn't sound like they treat their people very well. Oh, but this company sounds like they value their employees. Maybe this is where I want to apply. Nothing bad comes from shining a bright light on these issues.
And I want to talk about the dynamics of this issue for women in the workforce in particular, even beyond the disgraces of men like Harvey Weinstein or, Donald Trump. Industry, business has long profited from or taken advantage of women and women of color who in the past might have acquiesced or kept silent because their only choice was exploitation or harassment or gender bias or unemployment.
Yes. Women are just in a very different position many times in the workplace. You might be the primary breadwinner. You might not. If you have children, more than likely you're the one dropping them off at daycare. You're the one paying for daycare. And so it just puts you in a different, tighter position. Most single parents are moms. So you've got working women who may not have any income from either a spouse or an ex-spouse, and they can't really come forward because they can't afford to lose their job. I 100% think it's harder on women than it is on men, and I think it happens more to women than men because that's part of the bigger societal problem is women think that it's okay to be treated that way or, this is just part of the job. So that, again, goes back to why I just am so grateful to Ifoma because she said, no, this is not the way women should be treated and came forward.
What Senator Leyva said is exactly right. What I would add, too, is on top of all of the pressures from compensation, again, this is where healthcare and the fact that in our society we have healthcare tied to employment particularly impacts women and women who sit at the intersectionality of race and gender or age and gender, veteran status and gender, because when you are the primary caregiver or primary breadwinner and your dependents are on your insurance plan, then you speaking up is you deciding that you are willing to risk your children's access to their doctor or your children's access to their medication. That is not a humane choice for people to be faced with, and that's why there are so many people who can't afford to speak up. I wrote earlier this year about how I probably wouldn't have spoken up and probably wouldn't have hired a lawyer if I had kids when I was at Pinterest, because I knew in hiring my attorney, my hope was that the company would do the right thing and things would be resolved quickly and quietly. But I knew that in hiring an attorney and advocating for myself, my days were probably numbered at the company. And that's not a decision I would have been able to afford to make because I also had known that once I left or once I was pushed out, COBRA and continuing my access to insurance was going to cost $900 a month. That would have jumped up to $2,200 or $2,500 a month if I had 2 or 3 dependents on my plan.
Wow.
Yes, I just want to reiterate that. FOMA is so right. I have been the primary breadwinner in our family for the past 20 years. Our girls are now 29, but I had some issues at work where I felt like I was harassed, and I didn't do anything about it because exactly what FOMA said. Our girls were young. I also carried the insurance, and so you lose your paycheck and you lose your health insurance. How do you do that? So, yeah, that's exactly right.
Ifoma, I saw a headline recently that said, and I think the article actually referred to you and quoted you, it said that tech whistleblowers are having a moment. That's how they put it. With the signing of SB 331, ex-Facebook employee Frances Haugen testifying all over the world and revealing Facebook documents, transgender employees protesting and boycotting Netflix over the Dave Chappelle comments against the transgender community in his comedy special. There's this balancing of the scales of justice, so to speak, for an industry that, as we've already talked about, has a reputation for being progressive and woke. But the glass ceiling is thick in this industry, and sometimes equity is merely a financial term. Is that headline an accurate assessment of the legal climate for the tech industry and versus employees?
I think it's somewhat accurate. The description of the tech industry, an industry that has risen to prominence off of exploitation as progressive, I think speaks to the marketing that the industry has invested in, not to the actual actions of any individual company or the companies as a whole. To whistleblowers and whistleblowing having a moment, I think there are a number of things. The work that we're doing builds on work that was done previously. There wouldn't be the type of attention on the work that I've done in coming forward and that many others have as well without the Google organizers who put together the walkout years ago. We wouldn't have had the success of 331 without the work that went into 820. And so I think it's a combination of both time and successes building on one another, but also people realizing that there is power in speaking up. There's power in organizing and in working together. And in an industry that has been notorious for killing organizing and killing worker power, I think that companies, although they still hold much of the power, and there really isn't a leveling the playing field when you have individual workers versus trillions of dollars in resources, companies are paying attention, and they're realizing that they can't silence folks in the way that they did before, and certainly they can't silence everyone.
I think that is right. And I think that not only are tech workers having a moment, I think workers across this country are having a moment. We saw a number of unionized companies go on strike in October. I saw one headline that dubbed it Striketober. But I think that after COVID, workers are even more hypersensitive to the way they're being treated at work and are saying no more. And I hope that they do find their voices and come forward. But it is scary and it is hard. But workers deserve better, and they can achieve more if we all stick together. There are more of us, meaning workers, than there are of them, and those are the CEOs of companies. But it's just still hard.
It sounds like the CEOs of these companies, the corporate world, in the wake of the passage of and the signing of SB 331, are having their own moment, and the corporate lobby is already trying to advise its clients on the new legal landscape moving forward. And I've read a couple of the business-focused articles and different groups advising companies reevaluate your litigation strategies. So clearly you're having an effect, and there are concerns out there in the corporate world that by limiting NDAs in this regard, that these companies are vulnerable against meritless claims and that there could be more protracted litigation and more cases going to trial rather than a settlement because they're trying to maintain some company integrity. What do you both have to say about that?
It's the type of circular logic. If we can't silence them, then they'll speak up and it'll hurt the company. But if they can speak up, then it'll hurt. everything is going to hurt the company, how about don't discriminate and harass people?
Right.
If you don't do those things, if you don't allow those things, if you don't encourage those practices, then there isn't anything to defend the company against. There isn't a story to tell if there isn't wrongdoing taking place. We're really calling companies, their CEOs and their general counsels on this. Live the values that you state you have.
That's right. And there's no need for a secret settlement if you aren't doing anything wrong. And it just helps the company. It doesn't help the workers whatsoever. And companies are very creative, as IFOMA says, the circular argument. They're very creative, and they get people to buy in to their lies. So I think good. I hope they're reconsidering the way they do business, because now they have to.
And then a really important point to note, especially when bringing up these, in my opinion, specious arguments against legislation like this, is that companies still retain the right to have employees sign a release of claims. And at the end of the day, that is the most important thing that a company receives when settling any disagreement with a worker, that worker will not sue them going forward. So even though companies are now claiming that, we lose something and not being able to silence folks for the rest of their lives, what the company is gaining is incredibly valuable still, which is why they will continue to write these settlement agreements and these severances, because they want to ensure that people will not sue them going forward.
IFOMA, I want to talk about your new and evolving and perhaps a bit not expected role in your life circa 2021 as this informed, experienced survivor advocate of NDA silencing and the legal battles against not only the discrimination but also the NDAs. You have become a resource to employees not only in the U.S., but it sounds like around the world, tech workers and otherwise who are fighting in the same arenas that you've been in and going against these same corporate Goliaths that you've pushed back against for the last few years. And you have actually created a new online resource guide for tech workers in particular who are considering making these workplace complaints. I guess you would describe it as a one-stop shop where employees can see what resources are available, what their rights are. Tell us about that resource that you're putting together or have put together, and it's live. It's out there already.
Yeah, that's right. It's been a busy year for me, you could say. The Tech Worker Handbook is the resource you're describing and that I spent the last year creating, and I'm so proud is out and available for people to use. And what it does is combine resources from a number of organizations on topics like legal advice, how to seek it. Because when we talk about tech workers specifically, most do not have the background that I have, where I've worked with reporters my entire career, I've worked with lawyers my entire career, and so seeking out help from counsel was not something that was intimidating to me or that I had no idea how to start. And over the last year and a half now, actually, since coming forward about Pinterest, I've heard from hundreds, probably thousands of workers at this point who have asked questions about how to find a lawyer, how to talk to reporters, how to make sure that they're keeping themselves secure when they're working for a company that is in all respects a surveillance company. And so I put all of those things together in this handbook and this resource that's now freely available for people to look at. And one-stop shop is a really generous way to describe it.
Yes.
There's a ton of information on it, but what I want is for folks to approach any decision, particularly one as big as speaking up against a huge corporation, with all of the care that that type of decision requires. And for them to be as informed as possible about how to protect themselves and how to make a decision that will impact themselves and their families for the rest of their lives.
And this has been a collective approach, right? I mean, you're getting contributions not only in advice and counsel, but I assume also financial support from tech workers, people that have been in the industry and are considering themselves allies to you and your work.
That's right. So the different portions of the handbook were contributed to by organizations like YNS and the Signals Network, who have worked with whistleblowers and tech workers and workers in other industries as well for years all around the world. And then the work of the handbook, ability to put it together as a website, was funded by the Omidyar Network, who's been invested in tech accountability work for a number of years now.
And one could even say perhaps the blessing of everything that you have been through in the last couple of years, you are in that position to be of support, to be of counsel to those workers that are facing or anticipate facing this kind of legal challenge in the workplace. And you can say, I have walked that path, I have survived, I can be here to help you.
That's right. And it really, blessing is the right word, because it really does feel like one to be able to turn my own personal pain into help for others. And not only that, I feel particularly proud that the skills that I learned while working at these companies, at Google, Facebook, and Pinterest, are also what I've now turned into progress against them and against the ways in which they would continue to harm other workers.
Thank you, Ifoma, for putting together the handbook, because you have made it look easy to do what you have done. And I know, but many others do not know, that it is not easy. So giving people the guidance to know what to expect, to know that it's going to be a hard road, I think is just, that is a real gift. And then secondly, I would say that Pinterest did not know that they were awakening a sleeping giant when they asked you to sign an NDA. And so great job.
And Senator Leyva, you obviously are yourself a blessing in that regard with your experience in the workforce and in labor, and also with your legislative empowerment, legislative agency that you have. What type of response have you received over the years from survivors or claimants or even just traumatized employees? This is obviously resonating, what you're doing.
Oh, it is resonating, and it brings tears to my eyes when I think of the survivors that I've heard from and people who have said that this was life-changing to them. And it's just humbling for me, because I ran for office to try and make a difference. And on days when you think you have, or someone tells you have, it's really humbling. So I feel honored every day to get to do this job, and I've been at it for 7 years, and hopefully I can do some more good stuff with people like Ifoma for the next 5, but very humbling.
Ifoma, how are you doing in the wake of all of this? You are tenacious, you're a fighter, you're empowered, you're an advocate, but you are also a human being. It's been a bruising couple of years. You and your colleagues were done an injustice in your work environment in an era when we really should know better. How are you coping and moving forward?
Well, thank you so much for asking. I don't think about it enough and am rarely asked, so I really appreciate that. I'm exhausted, honestly. I think that's the simplest way of stating how I feel. It's a lot to not only do this work, but to have to relive what was a really painful and traumatic period over and over in every conversation where I am talking about it. So thank you. I am enjoying life in Santa Fe. I'm enjoying making ice cream from my chicken's eggs. I'm enjoying just being outside and being off my computer as much as possible. But I'm also enjoying all of the progress that's coming from the work that we've done. It is no small feat to pass a bill like 331 in the 5th largest economy in the world. And so I am so proud of us. I'm so thankful for Senator Leyva and the work that she puts in and that her team puts in day and night. Jessica and Sergio have been the most incredible colleagues and partners to work with on this as well. And so I'm just really thankful. And thank you for recognizing Jessica and Sergio, because my team does put in the hours. They put in the time. They believe what I believe. And I always say that I can have all kinds of crazy ideas and things that I want to get done. But if you don't have a team that believes the same as you believe and is willing to work as hard, we wouldn't get anything done. So I am very blessed to have such a great team. And I know they loved working with you too, Ifoma. So it was a win-win.
Well, obviously, it's a fabulous team that should stay together because the work product is extraordinary. So congrats to everybody all around. So as we wrap, SB 331 is a start. you are planning a national campaign, isn't that right, Ifoma? You've talked about shareholder resolutions, etc. Your work is not done in this platform either.
That's right. That's right. And having a bill or having a law now in California feels so good to say that is a great anchor to do the work from.
And I would just say anything that Team Leyva can do to help you with any project that you work on, we stand at the ready.
As we close here, it just makes me reflect on what's ahead, the public awareness, employer and employee awareness, the education that you both still have to do to some degree in your respective capacities to make employees more aware of their rights and their new rights under SB 820 and SB 331. And maybe I would also dare to say the acknowledgement of the restorative justice that has to happen to make our workplace culture more accountable and more aware. This is our fault as a community and as a culture. It's our collective fault and a responsibility of our community to redress and to reconcile with all of this that we're dealing with in inequity in the workplace. It's on all of us.
Yes, I think that was very well said, Brian. It is our fault. We have allowed so much of this to happen over the years. And what is the saying? It is not the voices of our enemy, but the silence of good people that are the problem. We cannot be silent. And when you see something, say something. Well, that should apply in every aspect of our life. When you see something, say something. And if we all start calling out bad behavior, then I have hope for the future. But we do have a lot of work to do. And we were taking some good steps forward, and we've really taken a lot of steps back after the Trump presidency, and I just think that we have so much work to do, and I'm in it to fight and do whatever I can to help, but we need people like Ifoma coming forward because she, unfortunately, has the real lived experience that we can try and change.
That's right, and both of you said it so perfectly. What I would add is it's not only our fault, but it's our opportunity now to make things better and to push back against what has taken place before. And one thing that I love as someone who's been a debater probably since before I could talk is rejecting the premise. We don't have to agree with the stated fact that this is just the way things work. This is how business is, because it can be better for us and for everyone who comes after us.
Yes, that is exactly right.
I am loving the sisterhood, this work and power here that you both have established, and I hope in some capacity you can continue your alliance and leadership together. Ifoma, thank you so much for your advocacy in partnership with Senator Leyva on SB 331, for your, I guess the word that comes to my mind is your ministry of counsel and information sharing and turning your experience into a valuable resource for others in the workplace who have or will have to walk that path. And I wish you strong community and some fun experiences with your chickens in Santa Fe, and also peace of mind moving forward. And I really appreciate you joining us today.
Thank you so much for holding this space for us to have this conversation.
And Senator Leyva, oh my gosh, what can I say? Your incredible policy priorities and your legislative empowerment, it speaks for itself in more ways than I can find words for. California really is a stronger state with you fighting for all of us. It's always a treat to share a podcast episode with you, and I wish you a great fall here as you get ready to come back, and best wishes to you and your family, too.
Thanks, Brian. Always appreciate you, and as Ifoma said, giving us the space to talk about these issues.
State Senator Connie Leyva of Chino and Ifoma Ozoma. And that closes this edition of Then There's California, a production of the California State Senate Democratic Caucus, with technical and production assistance and great ideas from Martin Ashley, Bob Brulty, Brian Shadden, and Rainier Saviniano, McLeana Woods, Ricardo Sainz-Ione, and the graphic design artistry of Tim Davis. From the state capitol in Sacramento, I'm Brian Green, and thanks for listening to Then There's California.